Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Courtroom buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Ugh, good morning. It's definitely Monday. Good morning, everybody. I literally did. You guys can hear me now? Yes. Okay. It's Monday. Good morning, everybody. I literally did, like, I said hello to everybody individually, but now I have to say it again, apparently. Good morning, Paula, Maria, Willow, Denise, Pickles. Hello, Lois. Hi, Denise. Hello, everybody. It is Monday. Definitely Monday over here. It is St. Patrick's Day as well. I definitely gonna get pinched because I am not wearing green. But I see a lot of people in green in chat, which is good. Morning, Fala. Hello, my friend. Good morning. Happy Monday. Um, guys, today it's gonna be, I'm glad in a way that today it's gonna be kind of a shortish day because I am too old to having recovering from hangovers. Today's the second day on recovery, and it's yesterday was not a pretty day. I barely got up from bed. Hello, good morning, Stephanie. Hi, hello, everybody. You all look amazing today. It is still a recovery day today for me. I had to pump myself out of bed this morning and say I cannot waste another day in bed, because I have already spent the whole day yesterday. I guess when you get to your 30s and like you try to party at a weekend, like you're still in your early 20s, oh, nah, it's oh no, oh, I. I am no, I'm not looking forward to that. Definitely not looking forward to that because I am on a struggle bus. I should have not gotten that hard on Saturday. But hey, we had a good time. Me and Garden Bot. We left for the wedding. Was about what I think it was about 10 o'clock in the morning. We left. Um 10 o'clock in the morning and we got home at around 7 a.m. the next day. So I think we went a bit too hard, um, of that, and I drank plenty of water. I I know, Denise. Don't. How you don't making me feel even worse. I am so sorry, everybody. I am gonna work on something extra special to make it up for it. I am so sorry. I was in bed. I tried to got up from bed, right, to go and come and do a members video. But if I would have done, I would probably look like a zombie, and it's not Halloween yet. I mean, I could have recorded for Halloween, and then we would have a Halloween members video already ready for that. But I don't think you guys would have want me to see the way I was looking yesterday, Denise. No, no one wants to see that. I. Hey, oh Maria, thank you very much. Happy St. Patrick's Day. Oh, everyone. Well, I am definitely not gonna celebrate that, cause I'm still recovering from one hangover. I don't want to go to another hangover. And hey, you made it back on time, Lois. Amazing. Hey, thank you very much, Maria, for your support. You guys are amazing. Also feel a lot better from Friday. I think I went hard on Saturday because I was making up for the fact that I felt horrible on Friday. Um, So I was like, oh, let's go hard or go home, So I went a bit too hard. But thank you very much, Maria. And hey, check you guys out too. You, Lois and Denise, today have a new emoji. That's awesome. That's amazing to see. Thank you very much for the support, everybody. And so yeah, so I apologize for the no members video yesterday. I feel absolutely terrible. I will work on something special this week. But hey, also Maria and Lois, I have sent out today the your prices. So they are on the way. Hopefully they will be there soon. But yay, the badges! It is gonna be today. By the way, I'm really sad. I need ideas of you guys. If you guys want to do something today after court, we could like hang out for a bit more because court is gonna be very short today. They're gonna start about 10 a.m. Eastern, which is in roughly 10 minutes, and they're gonna finish around noon time. So it's only gonna be a very short 2 hours court day. So if you guys need, we can watch something else, or it is gonna be an extra. Oh, it's okay. It's okay. No worries, Stephanie. Be very careful. Hopefully, the drive goes well and you get to your destination safely. So yeah, so it's gonna be a very short day today in court. I think the judge even expects the state to rest today, which I am not seeing, because hey, yeah, exactly. We all are green for St. Patrick's Day, so we definitely that everyone doesn't need to be pinched for sure. Not even, and we'll pretend the gray is also green. But we can pretend the gray is green. I am sometimes a bit colorblind because colors they are complicated. But yeah, so we can definitely think about something because court is going to be very short today, and I am not looking forward to that because I am ready for full-on court day. But no, they decide to be a short day. And oh, also I had hang on.
The fact that the court needs to review and rule on various motions that were filed over the weekend. What the court's going to do at this point is we're going to suspend further testimony for the day. I'm going to release the jury for the day. We're going to have the jury back here 9 o'clock tomorrow morning. In the meantime, the state is going to work to get the materials to defense counsel that they need for tomorrow. And we're going to have argument on the record about the pending motions. Starting at approximately 10:30, we'll have those arguments. And then tomorrow morning, we will reconvene the trial with the continuation of the state's case. Anything further I need to put on the record from either party?
No, I just hope it's adequate to say, I'll confirm from the state's perspective that the county and county attorney suffered a debilitating cyber attack on, as I've been informed, Friday afternoon that has gone through the weekend into the day, where every aspect of our system has been shut down. I just want to assure them that certainly, I've known Attorney Assistant for many years, but that we were expected reasonably to provide the transcripts. Candidly, I thought those were provided when we received them, and that's on me. But we certainly made efforts over the weekend, and we thought once again that this had been provided through a back door, in other words, private systems we were cobbling together. And I just want to assure the court that we're not trying to engage in some sort of practice here.
Of course.
Well, I mean, it's not even a thought. I mean, we tried to communicate. We knew something was wrong Saturday. We got a bounce back that was very strange early on.
Right, and the court has no concerns about that. And the only reason I wasn't putting more on the record is because I didn't think we needed to get into the details of your security issue, your cyber security issues at the county attorney's office. But yes,
Suffering. I appreciate that.
I understand that it's out of your control. That it's no fault of the state for this delay. That these things sometimes happen in trials, and so it's all understood. But that'll give us time to deal with the pending legal motions. And it was going to be a short day of testimony today anyway.
That's correct.
So we'll bring the jury back at 9 o'clock tomorrow. I fully anticipate the state will conclude their case tomorrow, and we very well may be able to get the full defense case in tomorrow. No promises of that, I'm not holding you to that, but, so in theory, this case will be wrapped up on Wednesday.
Thank you.
All right, very good. I'll see you both back here at 10:30 or so, and we'll have more arguments.
Very good.
Very good, thank you.
Thank you.
So you can release the jury, please. We can come back.
OMG, oh my days, what has just happened? What? So apparently, state's attorney got cyber attacked on Friday and gone. Hello everybody. Hello coming in. I hope you are all right. So apparently, the state's attorney was cyber attacked Friday afternoon. So they cannot proceed because they don't have, I don't think they have anything like evidence or access. I don't know. Let's go back and watch it again because since the feed kind of... Hey Rachel, welcome to the Green Gang. Hello, happy St. Patrick's Day to everybody coming in. Nice green looking on you. Welcome to the Green Gang. Let's wrap it up. Let's hear from the beginning to see exactly what happened. Ingo, because I had a little bit without sound, so let me see if where did they start. Thank you so much for the support, Rachel. Welcome to the Green Gang. Hope you enjoy. And it's alright, Livy, thank you very much. Oh, Lois, thank you very much for your... Oh, thank you, you guys. You guys are amazing. Thank you very much for the support. It is already a wild Monday. St. Patrick's Day is indeed, because... Let's watch this from the beginning, because we... Okay, just be ahead. It's going to be a jump scare for a moment while the sound figures itself out, but it's not me. You are there. Okay, Swan, we all green today, so we'll not pinch anybody. Even the gray is absolutely green, because that's the color I see. You identify as green. I agree with you, friend. Okay, just jump scare.
The court needs to review and rule on various motions that were filed over the weekend. What the court's going to do at this point is we're going to suspend further testimony for the day. I'm going to release the jury for the day. We're going to have the jury back here 9 o'clock tomorrow morning. In the meantime, the state is going to work to get the materials to defense counsel that they need for tomorrow. And we're going to have argument on the record about the pending motions. Starting at approximately 10:30, we'll have those arguments. And then tomorrow morning, we will reconvene the trial with the continuation of the state's case. Anything further I need to put on the record from either party?
No, I just hope it's adequate to say, I'll confirm from the state's perspective that the county and county attorney suffered a debilitating cyber attack on, as I've been informed, Friday afternoon, and has gone through the weekend into the day, where every aspect of our system has been shut down. I just want to assure, and that's certainly, you know, I've known Attorney Sissi for many years, but that we were expected reasonably to provide the transcripts. Candidly, I thought those were provided when we received them, and that's on me. But we certainly made efforts over the weekend, and we thought once again that this had been provided through a back door, in other words, private systems we were cobbling together. And I just want to assure the court that we're not trying to engage in some sort of practice here.
Of course.
I mean, it's not even a thought on this. I mean, we tried to communicate. We knew something was wrong Saturday. We got a bounce back that was very strange early on.
Right, and the court has no concerns about that. And the only reason I wasn't putting more on the record is because I didn't think we needed to get into the details of your security issue, your cyber security issues at the county attorney's office. But yes,
Suffering. I appreciate that.
I understand that it's out of your control, that it's no fault of the state for this delay, that these things sometimes happen in trials, and so it's all understood. But that'll give us time to deal with the pending legal motions. And it was going to be a short day of testimony today anyway.
That's correct.
So we'll bring the jury back at 9 o'clock tomorrow. I fully anticipate the the state will conclude their case tomorrow, and we very well may be able to get the full defense case in tomorrow. No promises of that, I'm not holding you to that, but, so in theory, this case will be wrapped up on Wednesday.
Thank you.
All right, very good. I'll see you both back here at 10:30 or so, and we'll have more arguments.
Very good.
Very good, thank you.
Thank you.
So you can release the jury, please. Let me come back.
All right, so yeah, I think we are going to be able to listen to the oral motion, so that's good. So at least there's not going to be court exactly, but there's going to be oral motions. So what happened was, State's Attorney's Office was cyber attacked. I was going to say cyber bullied. I'm sorry, cyber attacked on Friday afternoon. So they cannot carry on with testimony today because they're still dealing with that. So they are going to resume tomorrow at 9 a.m. Eastern, not at 10 a.m. as we've been. So I need to write that down from when I do the stream for tomorrow. It's 9 a.m. Eastern tomorrow, so we're going to be an hour earlier than usual in court with this. State is expected to rest tomorrow. I know it is very crazy. It's a crazy Monday already, and it's St. Patrick's Day, so it's not very good. Lucky good one for them. So we're going to resume with the jury at 9 a.m. tomorrow. State is expected to rest. Oh, happy birthday to your son! I hope he has a great day, Case One. I hope he gets to celebrate. I hope he has an amazing day. And yeah, oh, awesome, Case One. I hope he has an awesome day, the best of days. So yes, so State is supposed to Oh, no worries. I'll see you all tomorrow, Stephanie. Thank you very much for popping in. Thank you very much for your support, love. And have the most amazing day. And yeah, I'll see you tomorrow, 9 a.m. Eastern. Bright and early tomorrow. Yay! So State is supposed to rest tomorrow. And we should be in deliberations by Wednesday. So... and yeah, so Wednesday is the judge said that we might wrap up this. So do not forget to start playing the verdict game, guys. Prizes is still built then, so don't forget to play the verdict game if you already want. If you want to leave it until the end, it's fine. Oh, happy birthday to your mom, Denise. I hope she has the best of days. That's well, you missed the bombshell fire backyard. So there's not going to be a court with jury today. It's only going to be oral motions with the judge, which I am hoping and I'm expecting we are able to watch that. So that's why we're going to do it today, and then tomorrow 9 a.m. Eastern, it's going to resume with the jury because the state's attorney office got cyber attacked on Friday afternoon, so they are dealing with that. So they're not, yeah. So sadly, they cannot have court today. It was going to be a short day anyway. So yeah, no, of course, obviously, no problem. I mean, we're here to help each other and to get informed. So sorry, just Nightbot. So yeah, so it's gonna be an interesting. So we're gonna probably hear motions of evidence of stuff that happened. Yeah. No. Case one, I can't do alcohol. Let's not talk about alcohol. I went to a wedding on Saturday, and I think I celebrated it a bit too much. So let's not. Yeah. Paula, do not click on any emails with links. I think that's probably what happened. Someone clicked on the wrong link in the state's office, and now they are suffering. Yeah, no, case one, no mention of alcohol in chat because, yeah, I thought on Saturday I was younger than I actually am. Yeah, and that was not. Don't not click on anything. So. Oh yeah. Oh, no, that's all right. No worries. I'll see you tomorrow, Sherry. Thank you very much for popping in and supporting and have an amazing day. And I'll definitely see you tomorrow. No worries. I mean, it's just gonna be, I think, a short day today. We were already expecting to be a short day anyway. Yeah, don't ever click on any link because that is just wild. I get messages from couriers saying, "Oh, we cannot deliver your parcel. It's being on hold. Click this link to." I was like, "Yeah, I am not gonna fall for that." So, yeah, exactly. It's just like. Not well, yeah. I was already expecting it to be short, but not this short. I think they will take the cake. Well, I guess I can take the counter, today because we're not gonna need it, and I'll move myself there. So sorry, just moving myself to another side, and I can turn this off. Sorry, just making my. Oh no! What did I do? Uh-oh, I pressed the wrong button. There we go. You're all back. Sorry, I pressed being wrong buttons. I should not be trusted to do this because I'm always pressing the wrong buttons. Oh, not again. That thing is still happening. So, peeps, like, if you think that your comments are getting deleted or not posting, it's not us. It's just lovely YouTube. It's just some growing pains and for dropping some public message for no apparent reason. So just keep trying and trying it again until it comes through, or just try to change maybe the way you're saying, because sometimes YouTube gets a little bit funny. So just don't think that it's us that is deleting any comments. It is not. It's just lovely YouTube doing YouTube things. So apologies for that. Apologies for that, my friends. But it's just YouTube. Sorry about that. Well, I thank you for bringing that up. Green tea, Denise. Probably that could be an idea. Oh, let me turn off the sound from cord because it's making my ears bleed. Uh, I'll try to drink definitely green tea. Well, green tea is it not like supposed to be give you too much energy? Green tea, or is it? So it's supposed to be healthy, isn't it? So we don't do healthy things in this channel. No, I'm joking. um, yeah, so it's like definitely be careful with the emails, and I apologize that for that, Willow. So we're just waiting now for court to get back. I I I like green tea. I like the matcha green tea, but I just find it too healthy for me. No, I'm joking. It's like I like it, but what was the reason I stopped drinking? I don't remember what, like, probably it was because it was helping my memory and I did not like that. Um no, joking. But green tea is really good. I forgot what it was good for, because probably it's definitely not memory because it did not help my memory for sure. And hang on, let me put a little bit. Oh no, not that camera. Oh my days. This camera, but this camera. So we're gonna be listening to some oral arguments. I don't know what they are on about. Oh, I was like, I went through a phase, right? That I went vegan and I was being all healthy and eating nice and doing all things. Oh, well, yeah, well, I'll keep definitely keep your them in our thoughts. I'm so sorry. Sending you lots of love, my friend. Definitely gonna keep them in your thoughts. Ivan was. I thought that was why you came here for definitely the humor, the very and sorry. 1 second. I don't know why. Right. Sorry. Colds, small little colds. Oh, I'm so sorry. Paula, I'm sending you the biggest hug, my friend. I'm really, really sorry about this. We'll definitely keep her on our thoughts and sending good thoughts and prayers. Thank you very sorry about that. It's never easy. Sorry about that, my friend. Whew.
that's not the way to start a Monday for the family. So I hope everything keeps us updated. Tell keeps us updated, obviously. Um, it. Oh, I'm not gonna even attempt to say that name on stream because I cannot. Oh no, I will not say that correct, Rachel. Um. Ooh. What is that for the hangover? Yes, I think probably I'll need that. I will have to search that, but I am not gonna attempt to say that, um, because I will end up saying a bad word on stream. Um, oh my days, Paula, I'm so sorry. I honestly hope that they can remove it in a way, that it doesn't affect her vision either. So it's. Oh, I'm so sorry. Oh, sorry. I'm so sorry. It's absolutely heartbreaking that it is. Oh, not the news you would like, and for family and for like. I'm sorry. It's heartbreaking, definitely. Um. Oh, I will share your picture of the hair. So, then on Friday we were talking about hairs, and I was talking about how thick and voluminous my hair is, and Denise started a competition, with me about it. So I've got a picture of her hair, because she very kindly shared with me, on it. But in another words, while I'm getting this, which state starts with the ND? Because I can't think of it. Because my states are all wrong. But anyway, this is hang on. Is it doing it's oh, North Dakota. Okay, thank you very much. See, this is why I love you guys, because you guys know your states and I don't. I think I'm gonna have to share this to my computer, because I'm gonna have to save your hair in my phone. That sounded so wrong, Denise, because it's the reflection is not showing properly, so I just need to send it to my PC and then I can share the screen. Sorry, because otherwise, oh, North Dakota, right? And if I don't mind me asking, while I'm doing this, what is the time zone of North Dakota? Is it Eastern? Is it Because obviously me not knowing, I mean I can Google it, but I would have to um Central. Oh no, it's okay, Pickles. No worries. I will see you later, my friend. I absolutely we understand. I'm gonna miss you. I always miss you and everything, but it is Central. Okay, so Central, Central. Oh no. So hang on. I am in front of Denise's hair now. Hang on. So that's Denise's hair. Central. Okay. Central. That's I'm still in front of it. Sorry. Okay. So that is Denise's hair. This way. This way. That's Denise's hair. It's really long and very thick. I would be up in flames if I would have that, because I would be overheating so much. But yeah, we were talking about voluminous. I am not gonna show you mine because it is very beautiful hair. But can you like? And I said this, it's beautiful hair. Denise already knows, but the work that it takes, like with the hair, all how many Denise? If I can ask you, like, I don't want to put you on blast, but how many products do you use on your hair? Because I'm just curious, because that is absolutely gorgeous and curly. Yes, it's like the two-in-one of hairs. It's curly, long, voluminous. Well, three-in-one is the trifecta. Zero. What? Zero. Wow, that's amazing. But that's zero. Wow, my days. That is amazing. Just shampoo and conditioner. Well, a bottle of shampoo ago. That's it. Wow. I only also put I only put shampoo, conditioner, anything, and nothing else because I have no patience for that. Who has time and patience for that? Wow, case one, that is amazing. I used to have hair long, but it's it's too much work. Thank you very much, Denise, for sharing that with us. Really, really appreciate it. Um, so appreciate that you do and help us out. um oh wow, how it's like I don't think I would survive with the air. Yeah. Hey, Denise, do you buy them at Costco? Sorry, that was not funny. It's just me because I have a Costco problem. um Okay, so what we could do. Well, court is supposed to start soon anyway, but I had an idea. Okay, all right, that's fine. That's not too bad. Okay, North Dakota, it is 5 hours difference. Um. Oh. So it depends which county it is. Okay. All right. Thank you, Paula, for that. I really appreciate it. I am asking because I'm like, you guys know how I am, right? You guys know that I love covering trials, but we hop along between trials. Obviously, we follow them from beginning to end, gavel to gavel, and you guys already know that I'm already scouring our next trial before before Valo, because the thing is Valo, I think jury selection, they have a hearing tomorrow. Jury selection starts on the 31st. And most congratulations! Oh, well done, my friend. Oh, I am so proud of you. Well done. Ai, vamos, muito. Oh, congratulations. I am so proud of you. That is awesome. Congrats. You can do this. It is awesome. Very congratulations. Um wow. Um Congratulations. I can imagine that it's tough. I still struggle every day that I don't smoke, and it's been a while since I smoked. So it is tough, but you can do it. Perseverance and yeah, you doing amazing. I've almost well done. Very proud of you, my friend, and every single one of you. I think everyone who should be proud of everyone, because just waking up sometimes. So what I'm already doing is I need to starting uh oof, scouring our next trial, because the Lori Vallow, we are going to be following Lori Vallow here on the 31st. Yes, you are. Awesome. Definitely. You can do this. So we're going to be covering Vallow. Vallow starts the jury selection on the 31st of March, with expecting starting on the 7th, but so there's going to be a few days. So we're still going to be following the trials before Valo, and there is already a new one on the street. I just need to find exactly where the time zone is before I commit. So I just need to find more information. Please don't tell me that it's in. Okay, Grand. Oh my days. So I'm just, and that's the state, the North Dakota. So now I need Grand Forks County, North Dakota time. Please be. Oh, awesome. That is fantastic. So there is a very big possibility that we're gonna be next going on the Nicole Rice. Oh, I don't know anything about this case, so I know. I smoked for. It's gonna be embarrassing to say, so and unbelievable to say that the amount of time that I smoked. I smoked for very good. I'm gonna sound very very old to myself, because if I say 20 years, it is no exaggeration, right? I know I started smoking when I was about 13. I know, not good. And I always smoked. I always had the nicotine, and no, I have not smoked for 3 years. So it is very hard. Every day I still want, especially when I'm high stress, is when I want to do it the most. Um, and yes, it's wow. Yeah. So it's a long time. So it's just like quitting. It is very hard to do. It is not impossible, I know, and it is very well possible, but it's a very strong will thing. A very yeah, absolutely. But you can do this. Just persevere. If you need, we're here to help you out, keep your mind off. If you just want to talk and de-stress and just rumble on, DM me, and it's absolutely a pleasure, because I understand and you can do this, my friend. So yeah, so I need to. Oh, this case sounds interesting already. So, do you guys want to? Well, I don't know. It's like about 10 minutes until court starts. Do you want me to read you the article about potential new case that's going to start, I think, in the next day or two? We might be doing some catching up, but that's okay. That means we can do no breaks, no lunch hours, and thing. So, right, let's go. So, this case is North Dakota and Nicole Rice. They're calling the toxic roommate unaliving trial, red rum trial, but we're still gonna see what we're gonna call them, call the trial. So, a North Dakotan woman is standing trial on charges that she unalived her roommate nearly 20 years ago. Nicole Erin Rice, 37, is charged with a felony unaliving in the death of Anita Knutson, who was found pokey-pokeyed to unaliving on June 4th, 2007. So this case is from all the way back, 2007. At the time of the unaliving, the two women lived together, though friends said the two had a strained relationship. One friend told police they called Rice, telling Knuston, okay, this name is going to be so hard. Why do the names in trials are so hard? Are they trying to trick me or something? One way or another, I'm going to get you out of this house. Wow, Rice said. It looks like it was a cold case for a while, Willow. The body was found by the father of the victim, Knutson. I don't know. It's gonna be hard to say her name. What's her first name? I need to know the first name because I am Anita. That is hard, easy to say. Anita's body was found by her father, who came to the apartment after his daughter failed to show up to work and did not answer multiple calls. Despite evidence at the scene indicating that the unaliving was committed by someone with access to the home and was not motivated by death, it took nearly 15 years for police to make an arrest on this case. Yes, that I cannot say the last name, Willow. My apologies. Yeah. So police cited Rice's inconsistency statements when they arrested her in 2022. The Rice told police that she had been at her parents' farm the weekend Anita was unalive. Investigators said that she allegedly confessed to an old boyfriend that she had committed the unaliving and told a different friend that she been out at a bar in Russo before returning to her apartment. So that sounds awesome. I am sorry, but this sounds a very, very good trial. Sorry. hang on. Sorry, just seeing a message. I will, Willow, I think, did you send me the pronunciation? I think she did send me the pronunciation. Let me hear it, so before I say it wrong again. One second. Okay, I think I have it. I think it's Knutson. Is that correct, Willow? Oh. Oh no. Oh no. Okay, hang on. We have an alarm. 1 second, my friend. Because I don't think the oral motions are gonna be streamed. So hang on. Let me go somewhere else. Let me see if okay, right, hang on. Oh, hang on. Found another one. Oh, it's fine. I'll believe you. I absolutely believe you, Willow. I don't worry. I will take your word for it, because it's better your word than mine. Saying, yeah, Knutson. All right, see, it is correct. Thank you, everybody. So that's gonna probably be our next trial because jury selection starts today. So, and I'm sure it's gonna be pretty fast. I think might be, I don't know. So you might start tomorrow this new case. So on Wednesday, when we are on jury deliberations for this current case, we can watch openings for this one. So it works out just perfect. Obviously, I need to work out on everything, on the verdict game form and all of the good stuff. And yeah. Oh, also, during my very hungover state yesterday, right, I came up with an idea. Now, I think someone in court just fell out of the chair because I just heard a noise. Sorry. Oh, see you soon, Paula. Why do I say the wrong names today? I came up with an idea. I need to go grab it and show you guys. But it's still in the development. It's an idea that I think I came up with because when I was a kid, right? Give you a bit of backstory, like in it. I used to love football cards, baseball cards, the trading cards, and I used to collect them, and we used to be like stickers type thing. So I thought it would be a great idea to do the same for our channel. So we do have the spreadsheet, but I thought of doing like a baseball card of the if you guys don't think like it's a good idea, fair enough. A baseball card thing for our the cases that we follow. So this is just a prototype. There's something that I'm working on. It's still probably not correct software version of it. So you would have like the front with their mugshot, their name, and obviously the name of our channel. And then in the back you had all the information like the baseball cards have. And that could be something fun to do. I don't know. I think it could be an idea because I was thinking something a bit more intuitive. Like it's a very brief of the cases obviously we follow in the channel, not of yeah. And then obviously I would have laminated and everything. So I was just thought that it would be nice to have for the channel, and then if you guys want it, obviously you can always send it and share it with you guys because it's going to be like a pocket size thing. So this is just my first prototype, if you want to call it. I need to get it printed. I'll see if I can get it printed a double-sided, obviously. So yeah, I was in bed doing this yesterday. I think that was the thing to keep me kind of sane after. Oh yeah. Ooh, true crime playing cards. That would be nice. Can you imagine? You want to play a queen and it's Lori Vallow's pictures on the queen. Queen of Unalivings. Who would be the king of cases that we've covered so far? That would be interesting to know. That would, and the Joker. Oh, I can imagine who is the Joker. So, I think the Joker. Hey, the Joker could be Colin. So yeah, the Joker could be Colin because he was a joke that he got found out guilty. I'm sorry. How good is that? Please don't go. I say very weird jokes, but that is true. But that was very a joke. That yeah. Court should be please court. Just come in and interrupt me at any time, please. Just like feel free to interrupt me at any time, court, because I keep saying things that are absolutely crazy. Um, and I don't want everybody to go away. We'll see if they actually stream the oral motions. Otherwise, we might watch maybe some paroles or something, just to hang out a little bit more. Because I do want to hang out with you guys, since Gardemon had to leave me alone. What we could do is do some more research on a new case as well. Definitely could do that. As well, if there's nothing else to do, we could do some investigation, some watching some videos on it if there is anything on it. Um, Definitely could do that. Because that could be good to. Ooh, no way. Oh, I was gonna say no. Okay, there is quite a few like news reports about this case. Hmm. So we could do that. Um. Oh, I need to spell her name correctly, because otherwise it's gonna be. Yeah, we can just. Yeah, and then we can do some more research on our potential new trial starting Wednesday, because obviously we're not going to start that new trial until this one is on verdict watch at least. So yeah. Ooh, I know the 11 years one, isn't it? um what where was that case? Like, oh, I saw something about that case, the recent. Oh, hang on. Oh no, what am I doing? I don't even have this shared. Oh, my days. Here you go. There we go. I guess I need to move myself as well from where I am and back down. So what we're gonna do this morning in this trial is just our emotions. It's not the case in itself. um Yeah, I need to write that down. What was the name again? Oh, morning, 3D. Hello, friend. Good morning. Welcome in. So this is just oral motions from the, I think, both of the state and the defense. It is not trial because of what happened on Friday afternoon in the state's case. After they got cyber attacked, they are not able to carry on with the case today. They will be back tomorrow at 9 a.m. Eastern, which when they start, I can put the link already up for tomorrow, so I'm gonna work that in the background. But yeah, so that it's what's happening right now, and we've already kind of discussed about like our potential new trial starting Wednesday. Obviously, when this one is on verdict watch, that's what we do. That's what we do. And yeah, so I think they are getting ready. Hopefully, the coverage will carry on, because we would like to see. Otherwise, I think we. Oh, thank you very much. Oh, Connecticut. Oh, I like that area. That area was when that Michelle Troconis was. So we did not follow that one here, but I did follow it in another creators. So hang on. Now 9 a.m. Eastern to my time. It's on 1 p.m. So start around there. So no, you did not miss anything, Denise. It hasn't even started. You just missed my bad jokes. That's what you missed. Yeah, no one has missed that. Cut you. Just me talking. You missed my bad jokes. Oh no, I know. I would love to have gone, but it's yeah. Ooh, it's less than a month for my birthday. No one wants to talk about that. Getting old. Oh, I cannot believe. Oh, but over the weekend, right, on the wedding on Saturday, someone said that I looked like I was 25. Oh, I was so happy. I think I even gave the person a hug because they are so nice. They think that I was 25. I mean, that is good. I would love to be 25. Yeah, I know. I don't look. Oh, do I? Oh, yes, I know. But I'm not. Well, I am definitely not. I am gonna be 33 in a matter of a few days. So no, no one wants that. But I was very, very happy, and I am even happy with that. Thank you very much, Lois. Oh, I appreciate it. So definitely gonna check Kimberly Sullivan. Could let me spell correctly. Connecting. Good. See, but yeah. So this is gonna be. Did they say what kind of motions is that we are gonna deal with today? Because I did not, or they did not say that. I know they said there were several motions filed over the weekend, and I think even Friday. But I don't know which ones was. But hey, I was just thinking the juries gets the St. Patrick's Days off. I mean, it would have been better if they would have got told before they came into court instead of wasting time and to come into court and having to wake up, well, probably early to get ready and everything. I would have not liked it. Having to gone into court and then they literally dismissed me in 2 seconds after they will be there. Oh, by the way, you guys don't see it, but there is no more glow. I finally changed the curtain. Now I have a longer curtain that it doesn't glow anymore, I hope. I'm not glowing anymore. Yeah, it only took me like, a month to do it? But yes, Garden Pot did it yesterday, because he's still young. He was bouncing up of the walls yesterday because he recovers way faster than I do of having a hangover. But I don't think he was as bad as me. Well, I don't remember. Saturday is kind of a blur. Saturday night, so it's not a good point. I don't know if they have already started or not. I cannot hear a thing. No, yeah, the sound is on. I can only hear in the background. But we are just waiting to see what happens and see if we are privy to hear these motions. And we're gonna go from there. Really? Oh, I was gonna say, that suit looks a little bit wrinkly. Okay, Judge seems to come in. There we go.
Good morning, everybody. Thank you. You may be seated. All right, so for the record, we are back here on this matter of the state of New Hampshire versus Jason Levesque. This is 2024 CR 273. As I discussed earlier, because we're not having testimony at this point, I thought it was a good opportunity for us to address the various motions that were filed by the defense over the weekend. Oh, before we do that, though, counsel, I should let you know I have copies of my proposed jury instructions, which I did over the weekend, for you all. You're welcome. Do you have any? I have 3 sets there. So we should still have plenty of time that you'll have a chance to review those and get back to me. I have included, just so you know, I included the long form self-defense standard instruction. You know, there's a short form and a sort of a long form. I've included the long form self-defense instruction, which was my plan all along. So that basically matches, I think, what the defense was asking for in their proposed jury instruction. To the extent, Attorney Sisti, that there's anything, I think I've captured everything you asked for in your proposed jury instruction. To the extent that there's something different, obviously you're free to raise that. I did also include language about not only self-defense but defense of other, because I do think you have raised some enough facts that should go to the jury as well. So I've crafted it, but if the state wants to object to that, I will hear from you. And if you need time to think about those things. The other thing I did that's unusual in my jury instructions is, there's a standard jury instruction for prior inconsistent statements, and that prior inconsistent statements don't come in for the truth of the matter asserted, but they're only used to assess the credibility of the witness. I've chosen at this point, and I'll hear from you at some point about this, to eliminate that, because there really have not been any prior inconsistent statements that I'm aware of that have been used to impeach anybody in this case. And the only prior statements that have come in were the prior statements that the state put in as substantive evidence under the rule of evidence for prior recollections recorded. So I think it would be confusing to the jury if I gave them that standard instruction, which says basically you're not to consider out-of-court statements for the truth of the matter, when in fact there are some out-of-court statements that they can consider for the truth of the matter. So I think it's actually better just to not discuss prior statements at all and leave it open. But that, I just want to highlight that to both of your attention, because that is one change from the standard instructions that I did in these. Otherwise, they basically follow the standard instructions, but feel free to let me know if you have any concerns. All right. So that leaves 3 other motions we're going to take up at this point, and I think it makes sense logically to start with the motion for a mistrial. So I've reviewed the defense's motion for mistrial. I fully understand that the state has not had an opportunity to file a written response, given your computer issues. If at some point you feel the need to file a written response, let me know, but I think at this point we'll go by oral arguments. Attorney Sisti, it is your motion. I'll hear from you first.
Thank you, Your Honor. And, as a little bit of background here, this issue, or these issues, really didn't rise until Friday afternoon.
Mm-hmm.
And around 2:30 in the afternoon, it was announced at the bench on the record that Violette would not be testifying in this matter. And I can assert, and I'm sure the state will agree, that that is a development that was not anticipated. That certainly was not in play on the 3rd of this month when we were selecting a jury. And it wasn't in play when the court had contemplated preliminary instructions with the jury. I can say that voir dire on the defendant's part was framed around the assumption that the alleged victim in this matter would be testifying. And in fact, that assumption would have been buttressed certainly by the voir dire of the state with the potential panel as well. I think both the state and the defense were raising issues with the panel in expectation of Mr. Violette taking the stand.
Counsel, maybe you can fill that out for me a little bit, because I read that in your motion and I was a little, I wouldn't say puzzled, that's probably too strong a word, but I was curious as to how you would have voir dired the jury differently if you had known from the outset that Mr. Violette might not testify. What sorts of questions would you have asked, and what sort of bias or would you have tried to ferret out from the members of the jury that you don't think you were able to?
Yeah, we would have actually gotten into what I have proposed as a missing witness instruction with the court. And we would have delved into their belief on that particular issue. Some people would take that and embrace it. Some people may not have been able to follow that instruction. We don't know at this point in time. But it would have been something that would have had to have been raised, because maybe we should get into this a little bit deeper. When that is joined with a self-defense instruction, the voir dire is quite different than me trying to delve into them, trying to judge the credibility of witnesses. They would not have to judge the credibility of Violette. In fact, they would have a presumption, or they would have the inference that his testimony, in fact, if he testified, would have been unfavorable to the prosecution.
Right, but that only applies, that only works if the court were inclined to grant the missing witness instruction in this case. And that's so, I see how these issues are all sort of intertwined.
Yes. No, I understand that. I mean, although there's a difference between the missing witness instruction and the missing witness argument. The argument can be made without the judge's, without the court's instruction. There can be argument with regard to, why isn't he here? He's the alleged victim. There's no good excuse for him not to be here. That can be covered without the instruction.
Courts have allowed that. Courts have certainly allowed that.
Correct.
With the caveat that you can't ask the jury to speculate about things that aren't in evidence.
Right.
But anyway, carry on.
But the problem is we weren't able to get into it. And I don't know what the rules of the game were during the course of voir dire. And quite frankly, neither did the state.
Right.
I mean, neither did the judge. I mean, we were all sitting here.
Right, but to the extent that that's an issue, you can raise it in your closing, right? I mean, how?
No. I can't requalify a jury on closing. All right. I can't re-strike a potential juror on closing. I can't move for cause on a juror on closing. I mean, that's what voir dire is about. Mm-hmm. That's what jury selection is about. And that's why we're given and afforded the opportunity to question during the course of voir dire, and that is to vet out the issues that are expected at trial. This is a totally unexpected development. Totally unexpected development. And in fact, on the third, I mean, I looked at the note, and part of my question had to do with the intensity of the contact, with in fact, the initial arrestor aspects, the fact that they have to look at the credibility of the testimony of everybody, and then that was reasserted on the 12th, on the opening, where the prosecution asserted he was the victim on their opening. Right? Certain words that he would be saying, their version of what the words would have been on opening, which, by the way, he's never going to be able to testify to.
Well, my memory is, and I'll let the state talk about this, my memory was that in their opening, they almost, and I was struck by this, the state never used the sort of standard language you hear in openings, like, you're going to hear from Mr. Violette and Mr. Violette. At least my memory is, I don't recall the state making statements like, you're going to hear from Mr. Violette and Mr. Violette is going to tell you X, Y, Z, which frankly the court took as a, hint is probably too strong a word, but a suggestion that the state in opening wasn't certain that Mr. Violette was going to be available to testify as a witness in this case, and I'm sure that you must have been struck by that too, the fact that the state never once in their opening said that sort of language that prosecutors routinely say. I could be wrong about that. I'm just going by my memory of the openings.
Well, my note indicated that some of it was, if you leave fucking snow in front of my fucking house, I'll kill you.
Right, but that came in, but that's coming in from the defendant. I thought that they were saying that that's what you were going to hear that the defendant said that he said.
And I am stating to you that would have been a statement from Violette.
He testified, right?
Right. And there would have been more, but
presumably,
right. And frankly, that's where we were going with this, is that it's not just there, that there's intensity, that there are core issues in the case, that credibility is one of them. And in fact, there was an objection raised by the state on the credibility issue when I said that Violette wasn't straight with the prosecution, it was straight with the police. And that was raised and that was argued at the bench, and in fact that was a withdrawn part of the opening. By the way, I anticipated that if he did take the stand, all right, that he minimized this particular event. He would have had an interview, I think it was on May 29th of 2024 with the police. In fact, one of them would have been Detective Danny looking on in the CAC room, where Violette basically said, "Oh, I was just going out there. I didn't want a confrontation." I mean, I'll make that offer proof to you right now. That those are basically the words that he was urging the state or the prosecution to embrace, which are completely false. And these are the areas that, you know, we were setting up and getting ready to deal with him on. Okay? Now, these aren't small things. I mean, he's a big player here.
Oh, I agree.
Good. I mean, he's the alleged victim in a case. There has been, as the court just noted about 10 minutes ago, there's been evidence adduced at this trial where a self-defense deadly force instruction is going to be read to the jury, not only protection of himself, protection of his daughter in this case. So that end of it's in. The question is, if you join that for purposes of the motion to dismiss, and I have to jump back and forth, I'm sorry.
Understood.
If you join that with a missing witness instruction, the state's case is gone. It can't sustain itself if the alleged victim's testimony would be presumed or inferred to be unfavorable to the state's theory of prosecution. And there's a self-defense instruction. If you put the two of them together, it doesn't even make it across the hurdle of a motion to dismiss at the end of the state's case. It certainly doesn't make it past the hurdle at the end of all the evidence. The case can't go to the jury at that point. I mean, what's the issue? What is the issue at that point?
Well, I mean, setting aside the missing witness problem, the missing witness instruction, it was the mere fact that the witness is not available and that you've raised self-defense surely can't mean that the state can't meet its burden. Otherwise, you could never pursue a homicide case when self-defense is raised. Clearly, the state can meet its burden overcoming self-defense, even though the victim isn't available to testify.
No, I disagree vehemently with that statement. In fact, that's the difference between a missing witness and a deceased individual, because that individual is deceased. With a missing witness, that means that the witness in this instruction, there is a comment by the court where that individual, if that individual were to testify, all right, his testimony would be unfavorable. With a deceased individual, of course, you can't get a missing witness.
Right, so again, that's only if I give you the missing witness instruction.
And I'm arguing off the basis of the missing witness instruction.
Okay, maybe we should start. Maybe we'll have to start with that. I mean, that's. I was trying not to do all three motions at once, but we may inadvertently end up doing all three motions at once. If you want us to try to disentangle them or be heard more, I'm happy to do this however you want. But the missing witness instruction is tricky because, I mean, I think the case law is pretty clear. If you look at Ramos, I'm looking at State v. Ramos, 121 New Hampshire 863. It's a 1981 case where the Supreme Court held that the court should not give a missing witness instruction where the witness is equally unavailable to both sides. And my understanding from the offer of proof that the state made, and maybe we need to get into this at some point, as to what the level of proof needs to be on this question, and whether there needs to be more than offers of proof or some sort of testimony. But my understanding from the state's offer of proof previously was that the witness is unavailable to testify because he is simply not in an emotional state to testify. And it's basically, it's akin to a form of illness, right? He's unavailable because he cannot testify, despite their efforts to get him to testify. And when this court asked whether the defense intended to call this witness who was under subpoena, you informed the court at that point that you did not intend to call him as a witness yourself because of what the state had alleged, which was that he's not well enough to testify.
Let me clarify myself. One, I'm very familiar with Ramos's case.
Okay.
That was one of our initial cases in Manchester and Worcester, and I'm extremely familiar with Ramos. Okay.
Okay.
This is a completely different situation. Completely different situation.
Okay.
This is a witness that is aligned and would be more favorably tending to deal with the prosecution. In other words, this is a person who, in fact, the state's theory of prosecution is based on. One. Two, he is certainly more available and in contact with the prosecution than we ever could be. All right? And that's part of the test, by the way. All right? Part of the test is whether or not there's an affiliation with one party over the other. It's pretty clear there is. In fact, the First Circuit instruction is if it's peculiarly within the power of the government to produce a witness who would give material testimony, or if the witness would be favorably disposed to the government, of course it's going to be favorably disposed to the government. Failure to call that witness may justify an inference that his testimony would be unfavorable to the government. I mean, this is a simple test in this case.
That's the First Circuit's test, yes.
Well, I mean, we're in the First Circuit, and you know, it's the due process there, and that's an issue that's alive and running right now. But I also have to say, I don't agree with offers of proof on his unavailability, so I think we should take that off the table right now. There's been no proof as far as I'm concerned that he's unavailable, other than he's not being called. And that's what the facts of the situation are. I'm not going to call him. He's more predisposed for the state. At this juncture, he is the poster boy for their prosecution. He is it. All right. Now, I mean, the true test is, well, and if you look at any of the other states, in fact, just the Commonwealth of Massachusetts. It's the same test as what I just read from the First Circuit. If he's more affiliated with one party over the other, then boom, there you go. And by the way, again, you have to be really careful about why don't I call him? Well, we don't have a burden of proof, and that's also announced in all the cases.
Understood. I know that.
So, I mean, that argument means nothing. And the fact, by the way, that he's under subpoena, that means nothing. I mean, those all wash out in case law if you look through it. The real question is, who's he affiliated with? Who does he identify with? Okay? Who has more control over him? I would suggest the prosecution does, the victim advocate does, certainly not Siskey law offices, and certainly not Mr. Levesque. Okay?
Understood.
There's an actual hatred there. So,
But do you have a single case that you cited? I haven't seen one. I haven't found one myself where the court has given a missing witness instruction when a victim was, for example, sick, unavailable because they were ill. Do you have a single case where a court has given a missing witness instruction in circumstances like this, where it's not just that he's not here, but the representation being made by the state is that he's emotionally, psychologically unable to testify?
well, you know, maybe we should have known that before we started the trial, Judge. I didn't know it was such an acute situation, and I don't have one psychiatric report in front of me to sustain that particular conclusion. And I don't think the court can come to that conclusion without competent medical, psychiatric evidence before it, a full hearing on that particular issue, and not an offer of proof. And also, if he was suffering from that at the beginning of this trial, don't you think we should have known about that? Don't you think that that's something that the defense should have known, and that we should have been able to ask the court in a Gagney-type motion to review so that we can confidently cross-examine him at the time of trial when he is called to the stand, anticipated to be called to the stand? I mean, you know, those are the other issues. If in fact they were of knowledge that he was having a problem before 2:30 on Friday, we should have been notified of that. Okay. I would have had a motion in there asking for that. Okay, before he was cross-examined.
So I know I've taken you off track, and I apologize we've jumped around on issues, and I've sort of peppered you with questions. But so if you want to go back, I mean, we started with the motion for mistrial.
Right.
Which I think I understand your position, which is that if you had known the witness would not be available, you would have done voir dire differently, you would have opened differently, you would have prepared jurors for the idea of the missing witness and the missing witness instruction, probably would have been talked about earlier, etc. there anything you want to add to that?
Yeah, on that as well, and if he was suffering from some condition, all right, that we should have been notified of that as well.
Okay,
Okay?
fair.
So none of that's there.
The motion to dismiss, I mean, it's a little premature. I understand where you're going. You're arguing that between self-defense, if you combine the self-defense instruction with the missing witness aspect and the inference that the jury is allowed to draw for the missing witness, in your position is the state can't meet its burden in this case.
Right. And I want to be clear because I don't want any misperceptions. A missing witness instruction can't apply to your normal homicide case.
No, right. I understand that.
And I don't want to get off base here because I think we should all understand that that would be an impossibility.
No, of course. And I prefaced my question by saying, setting aside the missing witness problem,
Right.
the mere fact that you don't, the missing witness instruction, the mere fact that you don't have a victim who can explain what happened doesn't mean the state can't meet its burden of overcoming self-defense.
I would say
On its face.
in extraordinary circumstances, that may be true.
Well, in every homicide case where self-defense is raised.
Oh, yeah.
Right. I mean, in every homicide case where self-defense is raised, the state has to overcome, the state has to meet its burden of disproving self-defense without the person who can give that side of what happened. And that happens all the time.
That's a given.
But your argument is when you add the missing witness instruction and the inference which the jury is permitted to draw, but not required to draw, the inference they're permitted to draw, then you think it prevents them from getting over the hurdle of
Yeah, that's a problem, and it's also a subject of, I'm going back to the beginning again.
Mhm.
That's something that would have been addressed on board here, and that's something that would have been addressed on open. Right? That inference, how it impacts, and what we would strive them to do if we get to that point at the end of the case.
Okay.
So, I mean, we're left without that ammunition. We're left without that. And, I mean, I don't know what the timing's about. And
I'm sorry?
I've worked with Chuck forever, all right? In federal court, county court, public defenders. I don't think he's hiding the ball. I mean, I'm sure Sarah's not either. But, I mean, that's something that came up and kind of snuck up and bit us all on Friday afternoon. And it's difficult for me now to replay all the things I would have done knowing that, but there would have been a lot. I mean, the Gagney motion itself would have been filed immediately if we knew there was a problem. Okay? I mean, I would have been rightfully asking for his mental health records, or at least to have them submitted to you so that we could know whether or not there was relevant material in there to probably deal with two issues. One, his credibility, and two, what we're arguing about right now.
I may have misspoken. I didn't mean to imply that the court has reason to think that the complaining witness in this case is undergoing any mental health or psychiatric treatment. I have no way of knowing. I just was given the offer of proof from the state's counsel that he was emotionally not able to participate in the trial. But I'll hear from the state. I'm sure they'll clarify all that.
No, I'd like the opportunity for the state to, address any of these things. I mean,
Sure.
They came up quick, and they're not beautifully vetted for you. I have to tell you that. I mean, it's pretty quick research.
Oh, I'm not criticizing your research abilities. I know the motions have to be followed quickly.
So yeah, I mean, if the state wants to throw something in there, it may, quite frankly, be very, very helpful in resolving this.
All right. All right, I think we've discussed all the legal issues. I mean, obviously the self-defense, I think, is not an issue at this point because we've already moved on that. State, I'll hear from you on the motions. As you just heard, they're sort of all intertwined.
Yeah.
The state wants to try to
tease them out, feel free, but
Yeah, I understand. Look, let me just start with kind of the progression of our assessment of Mr. Violette and how we got to this moment with respect to his condition. And this clearly, isn't unusual. I mean, think in terms of a domestic violence case involving serious trauma to a victim. It's very frequently a fluid situation from beginning, middle, to the point of literally testifying about where a victim comes down in terms of their capacity to go back and revisit the trauma that's at issue and to talk about it in detail. We have had and frequently have cases of domestic violence involving serious trauma where we find ourselves in similar positions, and we make decisions about whether to go forward with, quote, victimless prosecution. And victimless prosecution, I have never seen it serving as a legal basis to invite inferences with the missing witness instruction. So more specifically to this case, I'll say that, or disclose that, right from the outset, after Mr. Violette was released from the hospital, police approached the issue of when and how to talk to Mr. Violette, who had been in, for periods of time, a coma. We heard when investigators went up there, he was in, quote, no condition to make a statement. And that issue was revisited, and I believe the police reports and discovery indicate a few attempts to go and talk to him where he simply turned the police away. And that ultimately investigators turned to the CAC process. That process was explained by Detective Danny, who indicated, when we have certain victims with children, for instance, go to the Children's Advocacy Center in order to make statements in a certain environment with certain trained interviewers with techniques that are designed to address, for instance, the sensibility of children who have endured violence. But that is not exclusive to children. We frequently use it for domestic violence. And we used it here, given Mr. Violette's experience. It generated a CAC. Then over time, and obviously we don't press witnesses during the pendency of, say, the 8-9 months of a case and constantly revisit their testimony and their experience over that time. In normal fashion, we approached Mr. Violette, I think within a reasonable period of time prior to trial, and it was clear to us that he was in a traumatized state, but not one where I was going to abandon hope that he would be able to testify. That it has been my experience over many years dealing with witnesses with trauma that it's fluid and there's a step-by-step approach. And at one point, he was able to disclose to us that his intention to testify. I'll say that during the course of trial, that the trial itself has been traumatic. That the turning point was, as I understand it, Mr. Violette actually watched on the live stream the body camera of Sergeant Hurley. I think you can recall was in fact a very real-time experience of him dying in the street, and he watched it. It was Hurley packing his wounds. It was Hurley putting fingers into bullet holes. It was watching blood drain from his throat. And maybe that was ill-advised. We didn't know that he was doing that. He had every right to do it.
Understood. And I went back and thought more about it after. I know I gave you a look when we talked about that. I mentioned I was not thinking the victim's bill of rights at that point in time. It doesn't have to be sequestered.
And so, well, he wasn't sequestered. My understanding is he watched it, literally on his phone down the hall. But my understanding is he went from there to a very acute state of PTSD. My offer of proof, and again, I haven't sent out an investigator, but that he sealed his windows, closed his curtains, and was in a non-communicative state, a state of high distress. We had revisited that with family members.
I'm sorry, Counsel.
The source of our information was Angela.
Oh, thank you.
By the way, the state of the record is, I asked without objection, what's his current medical state? It is still fluid. He went to a orthopedist last week that surgical requirements are continuing to unfold. But I also ended it with, how's his mental state? Because he goes into depressions and he has extreme PTSD. And I did not go into the details of how that manifested or how that manifested that week. But I just offer this as maybe not a substitute for gagging, but just as an explanation for the sequence of events that got us here to Friday. I had some contacts with him in our conference room, and it was very clear to me. I reached what is a subjective determination, not with the benefit of his physicians or treatment providers, but that he was not in a state to present testimony in this case. I concluded it in terms of what is akin to a medical issue that is trauma-based, not recalcitrance, not being reactive to the interests of the case itself, but simply to his current mental state. And that's what I got. And I've told you that we have been making efforts to get a summary letter from his physician, his provider, concerning his heart condition, concerns about this protracted trauma and revisiting the trauma in this type of detail in an adversarial process of what that translates to in terms of risk. I don't have that yet. That is a work in progress, but I'll concede to the defense. No, we don't have the conventional gagging. We have a witness, as I've described, that's gone through by the way, not surprising given what we've seen and know of his experience, a escalating traumatic response to evidence that he's heard, to my efforts to have him revisit this for purposes of testimony. And this is where we're at. I am not going to put this human being on the stand on my needs. And I'll accept the consequences, but let's get to the consequences. I don't think there are any as a practical matter, because this does not fit as a matter of law. First, the missing witness instruction, and particularly in the context of mistrial. The missing witness instruction, as the court noted, Ramos did indicate that it had to do with a kind of a concurrency, a balance of access to a given witness. I want to point out that when the defense filed a witness list, the last witness was every witness on the state's witness list. And that's expressed, and I get that as kind of this insurance policy. But bottom line is, Mr. Violette was not released from subpoena. In theory, the defense could call the witness, and I get why they would not, having more to do with, and no offense, or I'm not trying to be provocative here, but bad optics for a case where the defendant inflicted the physical and emotional injury and then put him up as Exhibit A of somebody who can't address the facts here. I get the tactics of it. But I think what we really need to do is then talk beyond. Both sides could call him at their peril, and that applies. And so does that automatically take it out? I'm aware that the First Circuit takes a slightly different view federally of this generally predisposed towards one side or another, but it doesn't end there. That's not the end of the analysis. The analysis from courts generally goes on to other issues like, is there a material aspect to this witness's testimony? Answer, sure. Yes. But the most significant issue here is twofold. One, what's the reason the defendant isn't appearing? And I think I've just addressed that. It's trauma-based. I think your comment on homicide and, for example, victimless prosecution of domestic violence is in fact on point for the reason prong of the missing witness instruction. There is a reason here. It's not just fickle, it's not unknown, it's not just a decision to be obstructive from the witness. We don't have that in that case, and it's not a witness standing up saying, you know what, I'm not going to give the defense the benefit of tactically advancing interests against me in a civil or criminal case. Don't have that here. The fact is that it could apply to homicides and domestic violence victims, but it doesn't based on the reason analysis. Just to dismiss homicides as just, oh, that doesn't make any sense because they're dead and unavailable. But what about all the body of evidence that, preceded the death? We can't get that in many instances. A consent case to high-risk behavior, the defense raises a consent defense to the victim was deceased during this consensual encounter, and therefore it's a negligence case and not a first-degree murder. Defense doesn't get an instruction that says the decedent isn't here, therefore you can infer that she consented to this high-risk behavior. It doesn't work that way, because that is not the spirit or intent of the missing witness instruction. So I do think there is a general guide to the notion of unavailability in that sense, the availability of that evidence, and that's the reason base. We're not there, he's not dead, but he's traumatized as the basis. But most importantly, let me just address what the core of our argument is. Almost all courts that I'm aware of, and by the way, I think I've conceded that my research has been somewhat compromised, but cumulative evidence. Here's the issue in this case. It's so narrow in terms of what the defense has ever claimed and the state's concessions about what's missing from this case. The defendant's actions, not missing. We don't need the defendant to say, here's what I did, and here's what the defendant did. It's on video from 4 different perspectives. We've lived that all last week. And so the actus reus element of this particular offense is fully established. He could get on the stand and said, I looked out the window, I saw it snowing, and I saw the defendant plow. That's all there. We've heard that from 2 other witnesses and 4 videos. Then I went outside and I confronted my neighbor about the snow. We've got that. The issue is the use of force. We've got that. The issue that the defense is saying that we no longer have is the ability not to establish verbal confrontation. The state virtually conceded it in opening statements. That quote that Attorney Sisti read from me in opening was from the defendant's claim. If you move that snow over to my driveway, I'll kill you and your family. Isn't from Kyle Violette, it's from the defendant. He repeated it 4 times during his interview, without change, without reference to his daughter, always a conditional threat. That was what I said in opening, and you're right. It wasn't because I knew he wasn't going to testify. It's because I started to have concerns, and I didn't want to anytime I can avoid a credibility contest over certain issues and focus on, if this happened, and we'll accept that it did, we still win this case. That was that opening. I accept. I accept tactical criticism from all my work, but I did, and I consciously did, a defendant point of view of this self-defense case to say that even from his perspective, the state wins, because this was there was no imminent use of lethal force, no reasonable force, and that's the issue here. And so the defendant, and by the way, I'll make this offer proof. The next witness coming on, Garston, we anticipate putting on the defendant's claim of what these threats were, and without impeachment. What he claimed happened next is in sharp contrast to the video, and we'll point out, everybody's been pointing out that, hey, you can't hear what was being said there. We've adopted from the outset that the defendant's claims about what Mr. Violette said will live with. as an aside, do we have countering evidence of that? Did Mr. Violette say something contrary? Yeah, he said a reduced, intense version of that. But so what is left for the defense is simply to say, I want to put him up to impeach him, to say, oh, you said that you went out there to not have a deadly confrontation, that you said something to the effect of, if you continue to, if I could be direct, fuck with my family, I'll fuck with your family, something along those lines, a slightly diminished version. Our approach to this has been, so what? And that's the heart then of this missing witness instruction, is that due to its cumulative nature of the evidence, the one side should not be able to invite the jury to speculate that it was something else. What exactly? That he did say, if you put snow in front of my driveway, I'm going to kill you and your family? I mean, we're already there. So that makes it about as cumulative as you can get.
Can you respond to the defense's argument that if we had known in advance that that this was going to be a victimless prosecution, so to speak, that we would have done different in our opening, we would have approached voir dire differently, that it's unfair to the defense because they didn't know this is going to be a victimless prosecution situation? What's the state's position on that?
Two issues. Then let's get to, I think, which would be the mistrial analysis. We would have done things differently. The mistrial motion, notably, at least I didn't see it, invoke the actual standard, which is manifest necessity. We're dealing with a standard of prejudice, of unfair prejudice, that is such a degree that the defendant's very basic rights to fair trial have been compromised. And what they initially raised in the motion is, we would have made tactical decisions differently. Tactics don't rise to quite that level. Tactics change. I think the court is well aware, we're all well aware doing this work, that it is about as organic and fluid a notion of preparation. Everybody's got a plan until you get punched in the face, and that's what happens here in a figurative sense. And this wasn't a punch in the face in that it's not planned, but witnesses frequently get up on a witness stand and say something different than you anticipate, and your tactics change. That's kind of the situation we're in. Although, I'll concede that this is of a, degrees matter, and still, this isn't one fact deviation. This is a central witness. But the differences in terms of what Mr. Violette would testify to, again, I've already gone over the cumulative nature of it. Walking out of his garage, putting on a shirt, approaching Mr. Violette, getting face to face, walking away, walking back, seeing a firearm be produced, turning away, getting shot, crawling home, being in really a state of dying, are the elements of this offense. Bodily injury, the intent to kill are established by the medical evidence, and the act of this offense is literally documented by video. So what degree of change of tactics are we talking about has to be measured and assessed in light of the actual evidence in this case. I was struck by the notion of, in voir dire, I think the quote was something like, we would have been telling the jury what to do about that, but that's not voir dire. We don't get up and tell jurors what to do during a case in voir dire. I think probably both sides pushed up against that line a little, as is the practice, particularly in this county. But that doesn't change, what you're able to do in voir dire. You're not supposed to be able to bring in case-specific issues of that kind of degree and ask the jury to get prepared to respond. That's opening statements at most, and even opening statements shouldn't be making argument. Opening statements can raise issues, and obviously if they had known that he wasn't going to testify, we both would have changed their tactics to address that, what is now something of an elephant in the room, but one that's really, frankly, overstated, as I say, given the margins of evidentiary and factual disagreement between what Mr. Violette would say happened and what the defendant has said happened. And that's, one, eliminates the missing witness instruction, and two, I think forecloses a mistrial analysis in this particular case. To summarize, this witness is not peculiarly available to one side. Both sides could call him. There is a rational reason other than obstructing the opposing side from obtaining evidence. And this is fundamentally cumulative evidence to the extent that it deviates from cumulative in the actual statement that is made, favors the defendant at the outset of this. That is, we're put in a position of conceding that point, which we more or less did at the outset of the case.
Thank you. What's your response to that?
Yeah, I appreciated that argument, and I think that we're starting to focus in on some very important points. One, again, we don't accept the offer of proof with regard to Kyle Violette presently being so traumatized that he is the equivalent of a dead person and is unavailable. Okay, so I just want to make sure that we're clear on that, because there hasn't been any competent evidence adduced at any hearing to support that factual allegation. I'll be extremely clear on that. And two, it also opens up a can of worms, because if the state had been dealing with Mr. Violette over time, and they came to a conclusion that he had some significant or substantial psychiatric condition, that's something we're supposed to know. That's something we're supposed to know, so that I can bring that to the attention of the court, and I can say I reasonably believe, under Gagnon, that there's an individual that may be suffering from a disability or mental defect, and I want the court to take the material, if it exists, and review it so that I can have relevant portions of that particular report or reports, so that the court can make a determination as to whether or not it's exculpatory, just like Gagnon, whether or not it's material, whether it's something that the defense should have. None of that was brought to my attention ever over the past year. None of it. We didn't know that he was in some kind of counseling. We didn't know he was. I don't know.
Well, I didn't hear the state say that, and I do want to just reiterate, to the extent in my questioning to you, I think I made it sound like I think I overstated my understanding of the evidence in this case. And what I heard the state say is that they understand he was having emotional difficulties, but I didn't hear anything about counseling or treatment. Or am I missing something? Or
no, but I did represent that we're trying to get a summary from a physician who talks about his PTSD and both the physical and emotional aspects of this. And again, you've heard admitted evidence from Angela that he's suffering from extreme PTSD, and that was, without objection, it is the state of the record.
Okay, Attorney Sissy, continue. Yes.
It's the state of the record. Where are the documents? Where's the background? And if you knew that prior to her taking the stand, if you knew he was suffering from such a condition, why didn't the defense have that material? Why didn't we have that before the court? So the court could vet it, go through it, and deal with it, and give us those documents that the court deemed that we should have gotten. This is an after-the-fact analysis. This is something that should have been taken care of well in advance of last Thursday. It should have been taken advantage. We should have taken advantage of that well in advance of the start of trial. I mean, if in fact the victim witness advocate in this office, all right, knew that there was counseling or there was a physician involved or some kind of psychiatric analysis, how about just a declaration that in fact he was suffering currently of PTSD, which we did not know. All right. Guess what? I would have been filing the motion. Any defense attorney would be filing the motion to determine whether or not there's something in those counseling records that would have exactly gone to a defect or a condition, or whether it would be impactful with regard to credibility, the ability to accurately recollect. I mean, all of those factors. But, you know, if this thing is sprung out of nowhere, and it's just an acute thing, and there's no anticipation anything like this would have happened, that's one thing. But right now we're hearing that that's not true. That there's been a concern for some period of time that hasn't been communicated to the defense or the court. That's what we're hearing. And that's a problem. That is a fundamental rights problem that was decided in August of 1992 in Gagney's case. That goes to the heart of being able to be on the same level with the prosecution in examining witnesses and getting information and making sure the court vets it properly so that we can come to court and cross-examine properly. Now that wasn't disclosed. And I want you to add that to the motion for mistrial as well. That was not disclosed. So if we're standing here at 11:28 on Monday, the 17th, and he's suffering from a psychiatric condition that we don't know anything about, that the defense doesn't know anything about, that amounts to cause in and of itself. I mean, that's material that would have been used during voir dire. That's materials that would have been used during open. I mean, we're discovering now. So, with regard to his mental condition, one, we deny the offer of proof. Two, if in fact there is a condition, we haven't been supplied with that information, we make that demand now. I can make the offer of proof that we never got anything like that. And if we did, you would have had a motion before you so that you could review the psychiatric records and determine whether or not they were material, exculpatory, etc., in compliance with GAG. So please add that. And I also state that the state's voir dire on March 3rd, 2025 got into serious bodily injury, threat of serious bodily injury, threatening, deadly force, self-defense. Let me assure you, Your Honor, if this was a victimless prosecution, that is an area that would have been delved into as well. Not only for the state, but of course for the defense. And we never got that opportunity. So voir dire is very important when you're selecting a jury so that you can properly vet for what you anticipate is going to take place during the course of trial. So we were denied on voir dire psychiatric material and the ability to discuss a missing witness, if in fact that would have been dealt with prior to trial. And quite frankly, it could have. We could have been addressing all of this prior to trial. But Friday came along, and again, unless it was a complete surprise to the prosecution, then I would state that the defense has been cheated out of an area that we could have delved into and dealt with on voir dire and open. And in fact, it would have changed certain categories of where we would have gone. Now on, how about Judge, that would have been part of us asking the court not to allow, all right, that video to come. Right. If he was so destroyed by something like that, if we had information that something like this would have triggered it, do you think it would not have come to your attention? I argued that it was prejudicial, much more prejudicial than probative. I think the court would have started tipping in my direction if I also could have played the chip that it would destroy the alleged victim in this case and render the alleged victim incapable of testifying in trial. But I didn't have any backup for that. I didn't know. I know that Court TV was certainly recording it and running it live. I also know that the alleged victim probably has a television set, and I would imagine that he's probably watching it. In fact, he may be watching it right now. But what I'm saying, and there is no sequestration of an alleged victim, and we all know that.
Right.
So I think that would have also come into play. All right. Or it may have, but it certainly would have been part of the argument. But again, the voir dire was part, and then the opening, so you're devoid of mental health information. That they were devoid of a missing witness possibility. They were devoid of all of that now has become real. It's part of the case now. We're talking about it right now at 11:30 instead of on the 3rd of March, instead of on the 12th of March. We're talking about it now. That's not the way these things are supposed to be running. And that goes to the mistrial aspect. That's the problem. It's only going to get worse. I mean, if I ask you now, will you order all of the psychiatric and medical evidence with regard to Kyle Violette, and 15 minutes from now we get a stack of it, and it's got psychiatric material in it that should have been given to us, we all know where the case is going. Right? I mean, is this an after the fact, or am I supposed to find out about this stuff next week? Is Jason supposed to become, somehow finally knowing what the case is about after it's tried? No, all this stuff's supposed to happen beforehand. There's a significant disadvantage here. But I have to say, I'll go back, we'll go back to Ramos now for a second, okay? I want to go back to that because I have this almost vivid recollection of that case. I know exactly where it happened. Right? It was in Manchester. It was on the west side. All right? It was an awful situation. And Ramos, in that particular case, you'll see there's a real clear indicator in that case as to what the facts are. There's nothing like this. There's nothing like this. I mean, that was not a witness that was particularly aligned with anybody. This particular case, there clearly is. And to say, well, the defense could call that witness is insanity. I mean, that's an alleged victim who has a completely different look upon this case than we do. And it was posited that he was a victim. He is not a victim, okay, as far as we're concerned. So, I mean, right out of the gate, we have different views of what's going on. And we look forward to his testimony. Because, quite frankly, when he did have that little soft interview with the CAC people that was witnessed by the detective in this case, he downplayed it like he was just going out there to say hi to his neighbor and please don't, put snow over on my driveway. That's not it. That's not what happened. And he said more. We would have adduced more than a conditional threat. And in fact, we stated there was more than a conditional threat. We took issue with that. Not only was there a threat directly to Jason, but you heard from his daughter the other day, there was a direct threat to her. She heard him say, I will kill you, and I will kill your daughter. And we were much more prepared to go into a lot of other areas, but he's not here. They're not going to call him. All right? If we would have known that, certain things would have been produced in different ways. But all I got to say, Judge, is this is a unique situation. I have never been thrown into this at all. You've been practicing a long time in a lot of different jurisdictions, and so have I. And so is Attorney Barr, so is Sarah. I'm just saying, unique situations have to have unique conclusions. And going forward now, with the specter of a psychiatric problem from a witness, and the base of the missing witness is that he has some kind of a trauma that hasn't been explained or delivered to the court or to the defense in the form of any competent medical evidence, that's not going to cut it. I mean, that's way off base.
All right, thank you. Attorney Barth, do you want to speak to the Gagne?
Yes, I do. I think this is a, sort of a confabulation of Gagne with one prong of the missing witness instruction, which is availability. Gagne would be, look, there's a criminal event or an accused criminal event happened, and there are issues about actions, perceptions, behavior in the course of that criminal event. And Gagne is a discovery mechanism to revisit generally speaking, a witness's, particularly a victim's state of mind, condition, during the course of charged conduct is our standard application of Gagne. That's different than saying, look, a witness has an emotional reaction predicated on issues that happened during the criminal conduct. There's nothing here where we're saying, Mr. Violette walked out of his house and engaged in certain conduct because he had PTSD, and therefore the defense should have records to assess that claim about the offense conduct. That's Gagne. This is literally a fluid situation on the eve of trial where revisiting these issues has had a consequence to a deeply, seriously injured person. I made an offer of proof about his witnessing that medical interaction with Hurley. Let me just say, these notions of the defendant's objection based on prejudice have nothing to do with this. The jury, no member of this jury that was lying on the street dying from 6 gunshot wounds in that scene. It was only Mr. Violette. And he has every right to view that material, whether it was through court television or our own expectation of presenting it as evidence. He had a right to see it. He did see it. There was a consequence. You don't want to accept that offer of proof? I get that. They're just simply declaring, I don't want to accept an offer of proof, though, isn't the same. It's State versus Dodopoulos, I think, where the court has commented on offers of proof at a bail hearing. When's a defense entitled to more? I think the court needs to make a finding that there's some basis in the context of this particular analytical framework, which is different than analyzing a victim during the course of an offense, and whether or not you need more to make a decision about the missing witness instruction. And that, again, I'll repeat that the Gagne framework isn't a necessary component for you to make the decision about the availability of the witness. And if this is contrived, this witness is not uniquely available to us, not willing to waive, for instance, a spousal privilege just for us to advance our case. This witness is available to the defense to call, certainly at their peril. But this prong, I think, is being really misstated in terms of a Gagne discovery type analysis. I'll return to this. The impact of the absence of testimony. They are claiming, on the one hand, that what he would have recast fundamentally is whether or not there was a direct threat, because the defendant, Jason Levesque, has always said there was a direct threat, and his daughter got up here and testified there was a direct threat. That's just not true. Daughter got up and testified, I heard something about the snow, and then I heard a threat to me and to Jason and his family. That was the condition. This is the threat. And by the way, Jason Levesque gave a detailed statement the night of the offense repeating the threat, probably 5 or 6 times, all stating a conditional threat. And so what the defense hasn't been able to do here is say, if only Kyle Violette were to testify, we'd get exculpatory evidence out. And they've never made that claim, not in their motion, not in their argument, not in revisiting the impact of prejudice here. He would have got up and delivered to us that it was a direct threat. There's no offer of proof. There's no basis to say that. It doesn't exist. And so what they want to do is put him up, have him say that it was a lesser threat, and then by just comparison impeach them. But what they can't do, for instance, is say, oh, Mr. Violette would have claimed that he had a weapon, for instance, and no weapon found at the scene. Mr. Levesque has never claimed there was a weapon at the scene. Didn't say, nobody's claiming, oh, you know what he would have said is, I've got a weapon here and I'm going to use it, and brandished it. We see on video that he isn't brandishing anything. And Mr. Levesque has never made a claim in the course of that interview. In fact, he specifically disavows it. I could see his hands, didn't have a weapon. And so where's both prejudice and fair inference? You know, if the court is going to give an instruction on missing witness, there's another ground, and it's in State versus Rubo, R-U-O-B-O. And I suffered through that case on the defense side of things. Didn't work out well. But there it was the court made the neutral missing witness inference, which is, hey, look, this witness is available to both sides. In reality, not. He had a Fifth Amendment right not to testify. None of that trusts in the Supreme Court case. But the implication was, look, you don't speculate, and that's the go-to rule for absence of evidence in criminal cases. I mean, what are they invited to speculate on? That he was waving a firearm around? It's demonstrably false. Can't speculate about that. Other issues that are provable because of the video and because of substantive statements that the defendant has offered, which we're about to put on into this trial. So, you know, in the absence of exculpatory evidence and an absence of fair inferences adverse to the state, the missing witness instruction without the neutral instruction is inappropriate.
Can I just follow up before you get to that consistent? Back to this offer of proof question.
Yeah.
And I don't want to push you too hard on your trial preparation and all that, but what I understand you to be saying is that the witness was here.
Yes.
Do I take it to be that if you had told the witness you must testify, I'm going to put you on the stand, was he saying he would not, could not? What was his position, or can you tell me that?
Yeah, look, I get that some of this is work product.
And I don't want to get into that.
Look, I'll just be transparent. I think these arguments in many ways are fair in the sense of asking for the reality of this progression. And let me just say that, you know, everybody had a concern. I mean, looking at these videos, here's a guy. I've had the same concerns in every domestic violence case where I see a photo of often a woman with serious injuries from someone that, you know, it creates additional trauma that's non-straight trauma. From the beginning of that case, I wonder whether or not they're going to be able to testify about it or willing to testify about it. Right. So this case, you know, we clearly had our eyes on from the get-go. I described that progression of police going out to his residence, being declined interviews, and eventually agreeing to be wheeled into on a wheelchair into the CAC. You know, by design setting to address situations like this. Then, closer to trial, reaching out and visiting. He's clearly in a state of distress, not one where I concluded he wouldn't testify. Not one where I concluded he would not testify.
So you're saying he would have if you...
At a certain point before trial, our assumption was, look, we're going to just get him here. He was under subpoena. He wasn't running away. Then it got to the point where he was starting to appear quite distressed. And at one point said he could not testify, would not testify, and then received a communication that says, no. He's going to testify, he's able to testify. In other words, this was not linear.
Right.
And so after that, it was this oscillation during the actual trial period where he was clearly being affected by the process, by revisiting evidence, and at no point, though, can I go back and say, geez, we reviewed documents about his treatment for PTSD. That simply became apparent to us during the course of literally ongoing trial preparation, during trial, you know? And I think that's fair to Mr. Violette. I certainly want to characterize this appropriately on his behalf. He deserves it. But on the other hand, I get the feeling that this is somehow a late-stage sandbagging effort. It's not. I thought our disclosure was appropriately timely in that, hey, this is it. And by that point, it was, Friday afternoon. We got to put him on or not? And it was not.
Right, and I guess I don't mean to push back on this again. I'm not trying to suggest you're sandbagging. I'm just trying to make sure I understand the facts. When you got to Friday and the decision was we can't put him on, that was my understanding. That was your decision. Do I understand that correctly, or was
my decision, but his statements by that point was that he was not in a position to testify. We revisited it, or we more broadly inquired with, say, Angela, and said, look, he's a wreck. In terms of responding to, I think I've mentioned the body cam image of him dying in the street in front of his place. And so I feel like we took necessary, appropriate assessments, both with him, no, can't testify, his wife, he can't testify, but we don't have, some sort of PTSD evaluation and some clinical assessment of consequences to his medical and emotional well-being if he were to. I don't have that.
Okay, so I'm just trying to make sure I understand, because I think there's a distinction between saying I, as the attorney, sort of made the decision that I think this would be bad for him, or on balance would be so harmful to him that I wouldn't want to put somebody through that. That is a different factual scenario than a situation where the witness is basically telling you, I cannot do this.
Both.
Okay.
I mean, I've had plenty of witnesses who have said, I can't do this, and we do a approach. Let me ask you this question. Get an answer. Let's do it in the courtroom.
Right.
Get an answer. What do we do with sitting down? Get an answer. We didn't get there into a progression of a highly traumatized victim. We've all been there.
I understand. And again, not trying to intrude on your work product, but were you able to do sort of, I don't know if you do this or not, practice sort of directs with him? Was he unable to do that?
Unable.
Was he unable to do that?
Yep.
Okay.
I would pose certain questions, and I concluded that he could not sustain an inquiry about the actual events.
Okay.
And I'll return to this. You can find, if he's not unavailable, then by definition he's available to both sides. They can go ahead and call him, go through this exercise on their own. But I'm not in a position. I agree to offer what I would consider to be conventional evidence of, here's a declared unavailable witness by virtue of this analysis from a qualified third party.
Right.
Not that as lawyers assessing an ability to conduct an examination doesn't bring some, I think, appropriate perspective to this, but I agree that this is a kind of a hybrid situation. My representation is I could not and will not call him. If the court concludes, by the way, for purposes of this analysis, that that's insufficient to declare him unavailable, I said, fine, put him up.
Okay. Thank you. Attorney Sisti?
It opens up other avenues, doesn't it? Opens up avenues like, just what material did you have to come to that conclusion? What exactly were the specific conversations? On and on. I mean, again, I want to make sure that my position that this is unshakable in that we don't accept the offer. We just don't accept it.
Well, I mean, you're not questioning Attorney Barth's representations about what his conversations with this alleged victim? You want me to not accept counsel's representations as to a conversation he had as an officer of the court? You think I should not accept that?
I think that it's opened up for you and invited you to go into the specific conversations? Yeah, I think he has. And he's invited us to do that.
Oh, I see.
But what I'm saying is, if it was 13 seconds of this, what we just heard, then no, I don't accept that. I'm sure it was much more. Okay? But the other thing that we also heard was we shouldn't speculate. And yeah, we shouldn't speculate. And if you're going to come to a conclusion of whether or not somebody's like medically in a trauma, all right, or psychiatrically unfit, it doesn't come from people with JD degrees. It comes from other people with specified medical or psychiatric training. And we don't have that. That's not before you. You can't just accept that. I challenge that. This is not a bail hearing, okay, with offers of proof. In fact, in bail hearings where there's offers of proof and you make a representation that somebody's mentally unfit, well, then usually you make that representation because you reviewed a certain document. I mean, you understand that, right? You don't just say, well, I'm making a decision, I'm not going to call. I'm not going to call. It would be inhumane to call. Right? That's not the test. The test is on unavailability, you're devoid of critical information to come to that particular conclusion. You were on the right track. What you're really asking, Attorney Barr, is whether or not it was tactical, right? Whether it was a prosecutorial decision, or whether or not he just declared him not a witness anymore. Maybe because of good reason. Maybe because he felt bad for the guy. Maybe because he wasn't acting perfectly okay. I wouldn't know that. I wasn't there. Because he's not equally available, quite frankly, to us. He doesn't come to my office. I don't have people that were reaching out to him. We were totally off limits. Let's keep this thing on the right tracks. The availability, all right, is clearly leans in the direction of the prosecution. They were with him Friday in this building. He appeared Wednesday. He appeared Thursday. He was with them Friday. So how can you come to an unavailability? He's responding to a subpoena. He's sitting down with the prosecution. He's discussing the case. He's discussing what he saw on television. Sounds like he's pretty cogent there. Sounds like we're having quite a discussion in a courthouse where there's a courtroom where there's a trial going on. Right? And he's not here. And I didn't hear that he just flat out said, look, I don't care if you call me, I'm just not going to testify. I didn't hear that. I heard that there was probably a decision that was made by Attorney Barr. I respect his decision. But again, it's one that you can't just accept and say that now he's unavailable. Okay? You can't make that connection. We never had the chance to even challenge that. And you know, if you're going to say he's like an incompetent witness or something like that, the presumption is he's competent until you can find him otherwise. Right? I mean, that's a basic 602 rule. There's nothing to that. But what we're dealing with here is speculation. You're speculating that he wasn't able to testify. You could have brought him in. You could have questioned him. You could have questioned him. I mean, it's one of those situations where it's not even adversarial. It's up to you to determine whether or not he would be a competent witness at that point, not the prosecution. It's up to you. And that's part of the rules of evidence. But if they bypass the rule of evidence and just pull the plug on the witness, then it's up to them. Then it's up to the state. Then it's their decision. And if they're making a decision like that in the last second before the weekend, when the case is almost in, other than him and one other witness, then, you know, we should be getting some notice on this. And again, I'm going back. This isn't some, and I don't think, frankly, I don't think the prosecution is trying to sandbag us. I don't want that impression to be made at all. What I do want to make the impression of is that there were other things for us to do in this case if, in fact, this issue, okay, would have come to our attention. And if it came to the state's attention that he was having a major mental problem prior to trial, that's something we're supposed to know. That's something you're supposed to know. That's something we're supposed to work out before we swear a jury. I mean, in all fairness, and it's one of those words that really is kind of overarching here. We were denied that opportunity. I was denied that opportunity Friday. I don't know where he was. I mean, when we went to the bench, I don't know if he was in the courthouse or if he was at home or at a counseling session. I have no idea. But I mean, it's too late, the horse is out of the barn. And if there's unanswered questions about him and whether or not they should have declared this situation earlier, then it's too late. We can't put it back together now.
Counsel, for the state, anything further you want to add?
Yeah, I just, again, want to reiterate that there's a difference between finding a witness incompetent and unavailable. I can go into greater detail. I suppose that my interactions, no, it wasn't this lucid. So how do you feel today? Feel like testifying? No, not really. That's not what's going on. But again, if this will take literally an evidentiary hearing to satisfy the defense, I don't think that's what the analysis is in this instance. It is a representation that we are not calling a witness, and the defense has decided, likewise, a witness on their witness list. They're saying they're not calling. I guess at that point puts it just as this unavailable witness, and you go to a second-tier analysis, which is, what's the nature of this evidence? It's cumulative. What's the representation about his absent testimony? It's not exculpatory. You haven't heard that. Just that we would have made sort of unspecified tactical decisions differently during voir dire. I'm not sure that's appropriate. And that certain statements that I made came from the defendant, simply not true. Excuse me, came from the victim, that's simply not so. I think we're left with a more conventional missing witness analysis than this Gagne incompetence issue. I have offered by way of explanation, but it's not what the state rests on. We're not calling him, defense isn't calling him. They shouldn't be allowed to invite speculation through a legal instruction.
Okay. I'm going to take these matters under advisement. We're currently scheduled to start at 9 o'clock tomorrow morning. I'll work on doing my best to get an order out later today so that you all know where we're headed. And
can I just, to the extent that it is even relevant, we are getting communication from our victim coordinator that a doctor is issuing a letter today. I don't know from what. I don't know that we'll even submit it, because my analysis is that we're not here to prove that he's an incompetent witness. But I'll wait to see when we get it. If the court wants it, the defense wants it, we'll obviously provide it.
do you know which, from his GP, like from a general practitioner, from a...
Your Honor, I can represent to the court, it's my understanding that this is coming from a physician that has been, I believe, involved in the victim's care for quite some time. I don't know if it's the only physician he's been seeing since the residual, since the incident occurred, but it is a physician that he has been seeing.
Okay.
Well, I'm asking too much to assume, but I want all of the medical records. I want medical records, I want psychiatric records.
What I'm hearing from the state is they're not aware of any psychiatric records, they're not aware of any psychiatric treatment, they're not aware of any counseling treatment. Am I correct about that?
That's correct.
All the above, and that we object at this juncture that it's not an appropriate Gagne proceeding. If the defense wants to file a Gagne motion, we'll respond.
Yeah, we will, because you referenced specifically that PTSD, from what I understand, is a physical condition. It is a psychiatric condition. So that's a good faith representation on my part to ask for his mental health.
I can represent to the court, it's my understanding this letter we'll be receiving is going to include some information, potentially an explanation for that. Again, it's not from a mental health professional, but that the letter that we anticipate receiving will likely address that in part. But again, we have no knowledge of counseling records or any specific kind of mental health treatment that has been referenced.
All right. Obviously, encourage you to share it with defense counsel when you get it. If you decide it's something you feel the court should see, if either side feels it's something the court should see in making its decision, please get it to the court as soon as you can. Otherwise, try and get an order out. Thank you all very much. Appreciate the arguments.
Just to request practically from the court, Your Honor, since we're still dealing with some technological issues downstairs, if it would be possible to in some way alert the office and pick up a copy of it of any order in person. I know we'll be here.
We'll get it to you.
today.
We'll get it to
Thank you. I just wanted to make sure we're all on the same page.
We'll get it to you in paper.
Old school, but works.
Appropriate 19th century novel.
You can send it by carrier pigeon, but I don't know that it'll get lost.
Thank you all very much. Well, thank you.
Right, a little bit of jokes in the end there. But wow. So let me see if I got it straight. This attorney, right? He wants the he had three motions that basically intertwine within each other. So one was a mistrial motion, and another one is he wants a missing witness instruction on the jury instructions at the end of the trial that basically says that the state was supposed to call a witness, but the witness was not available or did not want to testify. First of all, sir, it's not because the witness doesn't want to testify, it's because PTSD and because of all the suffering that is suffering because of your client that we've seen evidence and everything. First of all, he was not subpoenaed to testify. He was not under any gag order to not see the trial or anything because he was not on a witness list from the prosecution. The prosecution never said that he was going to call him, never gave that away that he was ever going to call him, because on his openings, the state never mentioned that, oh, you're going to hear from him, you're going to hear from the witness. The state never said that. So they literally saying, because they're saying that they did not voir dire the jury, they voir dire the jury in the way that would give that Kyle was going to testify, but they actually aren't. He actually is not going to testify. So he's all mad about that. And then for the fact that he says alleged victim, sir, we all watched the video of your client pew-pewing Kyle 6 times. So how can you say alleged? Your client admits to the crime. He just says he's self-defense. So why do you even say alleged victim? He's a victim no matter what. If he was in self-defense or not, he's still a victim. Sorry. This is got me riled up. Because this guy it's absolutely, and then he was like, oh, alleged PTSD, it's not real. Are you kidding me? So so, and if you are so upset that the state is now gonna call them correctly, why don't you call them? Why does the defense then not call him then? Why? So, because if he's so annoyed, so annoyed that the defense is not going to call him in to testify, and so, oh, I want this instruction, I want this and that, why don't you call him to testify, Sizzy? Why don't you call him, I think it's Sizzy or Sitzy, or is whatever your name is. Why don't you call him to testify? Because obviously it would not be good for your client. You're just trying to reach whatever it is that you're trying to reach. But because if he's so mad about it, why? Can you tell me why you don't call him as yourself? I just oh, this attorney, he make my head boil. Like an absolute, I it's, oh, sorry, yeah, gorgeous. Just I stopped the feed. I wanted to remove this. But I absolutely crazy that this lawyer is trying to say, first of all, that he is faking in a way, that he's not well enough to come to court to testify, but he's well enough to watch it and to so you never know how one day you are. One day you have a good day, the other day you're having a bad day. It's not his fault that he's having a struggle time, is it? It's your client that's pewed him several times. So, absolutely, I'm sorry, but I'm this attorney, I think it's a little bit, I want to say crazy, but I don't think crazy amount. It's and so what? He watched the trial. He's not under any gag order. He's not under a order that says that that he can't watch the trial. You should have thought of that beforehand, before the trial started, and he did not see his name on a witness list. And the thing is, the witness list, it's a
it's not like 100% you don't have to call all the people that are on the witness list. It doesn't mean that you have to call every single one of them. It's the potential witness list. It's those that you subpoena that you have to call and they have to testify, correct? So I just this guy, it's I mean, I don't know. It is crazy. It's absolutely ridiculous. But the sad thing is, we are not gonna know. Well, we are gonna know tomorrow when court starts how the judge decides in terms of these motions. Because first of all, we just heard that the one of the lady prosecutor. Yeah, exactly. Um, I absolutely agree. It's crazy him so desperate to go at him. Yeah, but then again, he can just call him as a witness, right? He could have just called Kyle as a witness, and then that'll be it. Resolves the issue. And I wish the prosecutor would have just said that. Well, if you are so angry that he's not gonna testify, calling him as a witness. So, yeah, exactly. Obviously, yeah. It's the yeah, but this they oh, absolutely crazy. But I was gonna say that the lady prosecutor asked for the decision also to be filed in paper, to give it them in paper, because of what the after the cyber attack that they suffered. Obviously their systems are still crazy. It's still not 100% sure, so they might still not have available. And even if we had available, New Hampshire is a state that we can't really see documents, I don't think. So we might find out only when starts the court date tomorrow, I guess. So this is just wild. I don't. This attorney definitely needs a wild check, because yeah. So I was gonna say, because maybe today then we can maybe take advantage of an early day. What do you guys think? Or do you want to do some court watching, or we can watch Judge Boyd, or I don't think parole hearings are online. Let me have a look if parole hearings are on. Parole hearings not. The thing is, I am not that too tired. I could do some work. I have some work that I need to get done. To be fair, I do need to finish the prize for this game, and I could go and maybe play some video games too. Just me playing. I think we're gonna do this. I think I'm gonna just chill for the evening. Nightbot is coming. Garden bot is coming home in a moment as well. What we're gonna do is tomorrow morning. The thing is already up. I just need to change the thumbnail because for some reason they did not record a correct thumbnail for some reason. What we're gonna do is we're gonna back tomorrow. We're gonna have a full-on day tomorrow anyway of court watching and watching this trial. And then we are gonna do that. You guys, well, I was gonna say enjoy your day, but some of you are working. I hope your work day goes quick. But yeah, we're gonna have a short little day and we're gonna enjoy as well. But I will get some green tea, Denise. I promise. Oh, hi. Hello, Santiago. Good morning. We actually breaking up for the day. It's been a wild morning, but you can rewatch. It's been wild. It's been promising. It's been great. And we already what I can do is as well, I can do some trial prep for on our next trial and everything. So there's a lot of work that I can do. But I think I might just go play some games. But have a great afternoon. Enjoy your lunch, everybody. Have a great morning, afternoon, evening, wherever you are, and I'll see you very, very shortly. Thank you very much for everything, guys, and I'll see you tomorrow.
And I'm a real-time crime professional.